Hello, I'm attorney Bob Babcock with Tully Rinckey PLLC. Today I'd like to talk about Miranda warnings and statements to police. What are Miranda warnings? Anyone who's watched a television show, a police procedural show, has heard the words, "You have the right to remain silent. If you waive that right, anything you say can and will be held against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, the government will provide an attorney for you free of charge." Those rights are called Miranda rights, and they come into play under two circumstances. Number one, when an individual is in custody and is not free to leave, they cannot be questioned until their Miranda rights are read. Now, my clients will say to me all the time, "Bob, I wasn't read my Miranda rights." Well, that could be because they were not in custody at the time. They were not being detained. They were free to leave. Questioning when you're free to leave does not require the police to give you your Miranda warnings, only when you are not free to leave. Now, if a police officer is detaining you, and then that police officer begins to question you about the events that are the subject of the investigation, Miranda rights are attached. Any statements that you make without Miranda rights can be subject to a motion to suppress. That means that those statements may have been taken improperly against the law without the Miranda warnings being read to the subject of the investigation. Now, what is the remedy if those Miranda rights are not read and the person makes a statement? Well, the remedy is not that the case gets thrown out. The remedy is simply that those statements can be suppressed and not used against the person in the case in chief when that case proceeds to trial. Those are the Miranda warnings in a nutshell.